Welcome to the Retiring Canada podcast, where our mission is to educate and empower you to make the most informed, rational, and productive financial decisions. Hosted by certified financial planner, author, and chartered investment manager Michael Isbister. You'll go behind the scenes to uncover the tips and strategies to help you invest smarter, optimize your retirement income, and reduce the amount of tax you pay. Michael is an investment advisor with Fundamental Wealth, a trade name of Harbourfront Wealth Management, a CERO dealer. And now, here's your host, Michael Isbister.
Hello everyone, and welcome again to the Retiring Canada podcast. In today's episode, we're going to discuss the fifth and final step to the fundamental retirement plan, estate planning. Specifically, I'm going to chat about the core estate documents you need to have in place, the disconnect that can happen when you have a transactional relationship with legal counsel, how decisions made in step 1 of our process trickles down to step 5, one crucial strategy that is often overlooked but will have a significant impact on your spouse or executor, and lastly, as always, a few action items for you to consider. Okay, so let's get into step 5 of the fundamental retirement plan, estate planning. Now, estate planning at its core consists of wills, a living will, power of attorney, and perhaps trusts. Taken a step further, however, it consists of the optimization of taxes, structuring of assets, it's your charitable and gifting strategy, it's all of these pieces working together for your stated objective and legacy. Yes, you will need to use a lawyer or attorney to draft things like wills and trusts, or a CPA to file your taxes, but estate planning at its very core is a plan that optimizes the disposition of your assets to your children, to your grandchildren, to your charities, to your church, and we need to plan for that. Now, everyone needs an estate plan, no matter how much money you have. Of course, the more money and assets you have, the more complex an estate plan could possibly be, and the more things you have to plan for. So today, let's discuss step 5 of our FRP process, estate planning, and chat about the different aspects of a cohesive estate plan that we cover. Starting off with the documents you should have in place, how titling assets impacts how they are treated at your passing, the use of trusts, the difference between assets going into your estate or staying out of your estate, gifting, charitable giving, and the importance of consolidating assets. The goal is to have all these different pieces moving together to bring your goals into fruition. Now, not all of you will need every aspect of what I will discuss today, but it's important to have a good understanding of what's entailed to ensure nothing is missed in your own estate plan. So first off, let's start with the basics. What most of you think about when you hear someone like me talk about estate planning, the documents. Likely the first thing that jumps to your mind is a will. Next, maybe a living will or advanced healthcare directive, which outlines your healthcare wishes and medical preferences. After that, you likely think of a general power of attorney or enduring/continuing power of attorney, and finally a living trust, also called an inter vivos trust. So let's take a moment and go through each of these. First off is a will, which I think most of you listening fully understand the importance of a will. That said, I continue to come across circumstances where prospective clients have either, have an outdated will that no longer reflects their wishes as their circumstances have changed, or simply have no will at all. Having an up-to-date will that's well thought out will be the cornerstone of your estate plan, which should be reviewed whenever there's a major event in your life, and at a minimum every 3 years or so. During my tenure as a certified financial planner, I have read hundreds of wills. And although I'm not a lawyer, our unique perspective of being the quarterback of our clients' financial affairs gives us a unique understanding of the big picture. Here is a simple example of a scenario we come across. John and Jane Prospect come to us and are confident their estate plan is in good order. And why shouldn't it be? They just had their will updated 2 years ago. After going through the fundamental retirement plan, we find a few discrepancies between their intent and what will actually unfold at their passing. First, after reviewing their investment statements, we noticed a few direct beneficiaries listed on life insurance policies and registered accounts that don't match what's stated in the will. Second, we noticed a substantial gift that was given to one of the children 5 years ago for a down payment was not documented. And lastly, we see that there's no consideration for digital assets. Let's go through each of these. When you name a direct beneficiary on an RRSP or life insurance policy, at your passing, these assets bypass the estate and go directly to the beneficiary. Now, when that beneficiary is the surviving spouse, typically that is the desired outcome. However, if, say, an adult child is named as a direct beneficiary on an RRSP account, for example, they receive that asset 100% tax-free while the estate is on the hook for the tax bill. In the case of gifted money for the down payment, not having this in the will may lead to an unequal distribution at the last passing of the parents. If this gifting was mentioned in the will, it could be used to decrease that beneficiary's share of the after-tax estate proportionate to the gift received years prior. If not mentioned in the will, at the very least, this gift or loan should be properly documented and then storing that documentation with the existing copy of the will. And lastly, the omission of a digital asset clause may make it very difficult for your loved ones to access accounts such as your social media profiles, digital photos and music, cryptocurrency, and more. When the will was created by the lawyer, he or she did so with their best intentions in mind and with all of the information they had available. And this is where the disconnect can occur. Typically, individuals and families have transactional relationships with lawyers for their real estate needs and when they need a will. Rarely is there a strong, long-standing relationship, especially one that is as deep and robust enough for the lawyer to truly understand you, your family, and your finances. I just want to say here, I am by no means taking a shot at lawyers, not at all. I have a number of very strong relationships with lawyers who focus their practice on estate planning, and I know for certain they turn over every rock when building these estate documents for their clients. However, as with any profession, you will find generalists and specialists. My industry is no different and arguably more fraught with unqualified people giving advice than most other industries. I guess what I'm trying to say here is that you want to ensure you work with a lawyer or advisor for that matter who understands your unique circumstances and takes the time to understand you and your family, especially when drafting your estate documents. Okay, a lot more to cover here for documents than just wills, so let's keep going. The next document to ensure you have is called a living will or advanced healthcare directive. This document states your wishes to your family and healthcare providers in the event you are unable to make medical decisions on your own behalf. It helps to take out the guesswork and manage the emotions of your loved ones during a very difficult time. Next are powers of attorney, whether it be general power of attorney or an enduring power of attorney, also referred to as a continuous power of attorney. These allow you to appoint someone as a fiduciary who must act in your best interest. One of the core differences of being a general power of attorney is that it ceases if the grantor, the one who created the POA, loses mental capacity. The enduring or continuous power of attorney remains intact even after the grantor loses mental capacity. For most retirees, this is the document we suggest as a part of your estate planning documents, especially as you age. Lastly are living trusts or inter vivos trusts. Now, there are a number of different kinds of living trusts, such as alter ego trusts, joint partner trusts, or family trusts. Now, without getting into the weeds, these types of trusts are generally set up for the following reasons. First is to protect your assets and the administration of your assets in the event you become incapacitated, to ensure your care is provided for. Another reason may be to simplify your estate and transfer assets to your beneficiaries more efficiently while bypassing probate. Another purpose may be to protect assets from creditors and maintain privacy and confidentiality, as trusts are not public record like a will. Lastly, high-income earners may also consider a trust structure as an income splitting tool to lower household income tax by splitting income with a lower income spouse. In general, these types of trust structures make the most sense for more affluent families. But as with all financial planning solutions, they are personal to each and every family's personal situation. It's best to have a discussion with our team and or your tax and legal counsel to determine if you should consider an inter vivos trust. Okay, so these are the typical core documents we look for and discuss with our prospective clients: the will, power of attorney, living will or advanced healthcare directive, and inter vivos trusts. Now, there are a number of other estate planning considerations we review and discuss with clients based on their specific scenario. This can include a charitable giving strategy to their church or charitable organization. Here, we want to review cash donation options, setting up a donor-advised fund, or perhaps gifting securities directly. The last point, gifting, say, stocks, a mutual fund, or ETF directly to a charity. Did you know that if you gift the security in kind to the charity, so not selling it, transferring ownership, you or your estate can claim the full donation tax credit and not pay tax on the capital gain? This goes all the way back to step 1 of the investment allocation discussion of our FRP process. During that step, we discussed the investment structure you currently have, which involves understanding taxable gain positions that could impact your income and tax plan. Through our detailed process, if we discover you do have some charitable intent now or in the future, it will impact each and every step of our process, all the way down to estate planning that we're discussing today. Every choice you make impacts your future trajectory. Another topic we discussed during this process is the current amount of estate tax and probate tax payable on your current assets. This again involves a review of your will, but also your corporate documents, titling of your principal residences or vacation homes, beneficiary designations, and more. Again, we want to have a clear picture how all of these moving parts will impact the final estate tax and probate. And we can only do so by rolling up our sleeves and getting to know you and your family. Lastly, I saved the best for last as I think it's incredibly important, but I believe it often gets overlooked, and that is the consolidation of your accounts. There is no reason for you to have 15 or 20 different accounts spread across multiple institutions. Part of our job when a client passes away is to help executors with the probate and transfer process and taking responsibility for as much of the paperwork as possible on behalf of your spouse or executor. An unfortunate part of our business is that we have a number of clients pass away every year, and we understand how difficult it is, and we are familiar with the paperwork. What we don't want to see happen, so say example where a husband passes away leaving everything to his wife, during a time of mourning, she is now responsible for gathering information and unwinding multiple accounts across multiple institutions, which in reality could take years to complete. When everything is simplified and organized, it also helps to limit all the different institutions, the follow-up, the phone calls, the bad instructions and information, the different requirements and paperwork, the tax consideration of retirement accounts and non-retirement accounts, keeping track of adjusting cost bases and income distributions. As you probably have gathered, having 10 or 20 accounts spread across all different institutions would be a nightmare. So please consider consolidating if you don't need all of those accounts to make things easier for your spouse or executor to manage, because we never do truly know when we're going to go. As you can see, there is a lot more to estate planning than just having a few documents in place. It's the combination of making sure that your goals are in alignment with how you title your accounts and property, your charitable giving strategy, your gifting strategy, all of it. And it's all a part of your overall estate plan and the fundamental retirement plan. So we started off this series with step 1 being investment allocation, step 2 income planning, step 3 tax planning, step 4 healthcare planning, and finally today step 5 estate planning. They all work together to create your own personalized fundamental retirement plan. In the next and final episode in this series, I will discuss our onboarding process and what you can expect from the first day, week, month, and year of working with our team. Okay, so that'll do it for today. Here are your action items for today's episode. First off, if you don't have a will, your circumstances have changed, or 3 or so years have passed since you've updated your will, this is your reminder to either get a will in place or review your existing documents to determine if they need to be updated. Next, don't cheap out. I know that's blunt, but I highly suggest you involve proper legal counsel to draft your legal documents. In today's day and age, there is no doubt a lot of stuff can be completed online. But when it comes to something as important as your estate documents, I cannot urge you enough. Please seek proper legal counsel. Preferably counsel that has a deep understanding of your personal finances. If you don't have that kind of relationship with a lawyer, be sure to include your certified financial planner to add perspective and perhaps even meet with your legal counsel to help you draft these documents. Lastly, if you're looking for a coordinated approach from a team that looks far past just investments, be sure to visit our website and check us out. Okay, so that'll do it for today. Make sure you're adding us to all your socials, LinkedIn and Facebook. Be sure to check us out at our website, fundamentalwealth.ca or retiringcanada.ca. If you enjoy the show, please subscribe and leave us a 5-star review in your favorite podcast app. Be sure that you're signed up for our weekly Retiring Canada newsletter. And hey, when it comes to your retirement, don't take chances. Make a plan so you can retire with confidence.
All comments are of a general nature and should not be relied upon as individual advice. The views and opinions expressed in this commentary may not necessarily reflect those of Harbourfront Wealth Management. While every attempt is made to ensure accuracy, facts and figures are not guaranteed. The content is not intended to be a substitute for professional investing or tax advice. Please seek advice from your accountant regarding anything raised in the content of the podcast regarding your individual tax situation. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.